First case to come before the court is State versus Young. Each side will have 15 minutes, and the appellant may reserve up to 5.
Thank you. I would like to reserve 5 minutes. May it please the court, my name is Richard Drucker.
Sir, you can come on up here.
Oh, okay.
That's fine.
I'm sorry.
I started looking and I'm like, man, you seem so far away.
I haven't argued in this
That's okay. It's
room
confusing.
before.
There's 2 of them there and it gets very confusing. So go ahead.
Sure. Thank you. May it please the court, my name is Richard Drucker. I'm the attorney for Roy Young. I'd like to focus in my argument today, in the brief time I have, to what I believe are the issues that are constitutionally significant. However, I don't mean to detract from any other parts of our brief. I'd like to start by talking about what I feel is a substantial ineffective assistance of counsel claim. Specifically, the most shocking thing I read in the transcript was defense counsel's opening statement, where he specifically told the jury that my client got drunk, struck his wife, the police were called, and he was taken to jail on charges of domestic violence. The indictment did not contain a count for domestic violence against his wife. These are clearly what is defined as other bad acts. As the court is well aware, bad acts tend to draw away from the minds of the jurors and cause them to look at the emotional issues, the exciting, misleading issues of the bad acts. There's absolutely no reason why defense counsel should have kicked off this trial in that regard. And in fact,
well, the prosecution raises a good point, don't they, in saying that, you know, you get that all out there before it gets in some other way, and then you know, paint your client in the best light possible that, yeah, he may have been involved in this altercation, but he's owning up to it and is not hiding anything.
the altercation had nothing to do with this case, Your Honor, and what I would say to that, as a trial lawyer that's probably tried about 200 cases, is I can tell you these are types of issues that you don't want the jury to hear.
Well, how are you going to prevent it from coming in?
It's irrelevant to the case.
But you can't prevent it, sir, right?
No, it's in my opinion, Your Honor, respectfully, this evidence is other bad acts evidence, and clearly the case law dictates that this type of evidence would not come in.
Well, it comes in sometimes just explaining why police arrived at a place, explaining why, you know, the police were called, just background information.
There was no reason why the jury had to know about the fact that there was an incident that was unrelated to the acts that were charged in the indictment. And specifically, on cross-examination, defense counsel examined Brittany Bias about it, Shirley Morris about it, Sheila Murray about it. In the case of Shirley Morris, defense counsel on cross-examination even got Ms. Morris to say that in the Oberlin Municipal Court, Mr. Young pled guilty to a menacing charge in relation to that arrest, which clearly would not have been admissible at that point in time. The jurors were repeatedly reminded by defense counsel, reading the transcript, that Mr. Young is a very bad person who gets drunk and beats family members. Clearly in this case, there was no count for domestic violence, and in my opinion, a case where there was no physical evidence of the crimes that were alleged in the indictment, the simple fact that testimony was introduced that Mr. Young was a bad man is what got him convicted. And I believe that's very unfair.
What do we need to do with Mr. Young testified, correct?
It's correct.
And it's my understanding that, I don't know if it was on direct or cross, but he testified regarding this incident of domestic violence.
His testimony was extremely short. I don't think with Mr. Young, the defense counsel got into the issue of what happened in court, where he was in court, what the result was. However, certainly any evidence regarding this incident would have been inadmissible.
Right, so you're arguing that it was ineffective assistance not to object, correct? At the get-go, for trial counsel not to object to it, but then are you also arguing it's ineffective assistance for the trial counsel to put Mr. Young on the witness stand?
Well, frankly, from a strategy standpoint, he didn't need to put Mr. Young on. There were many witnesses that testified prior to him. Whether or not that act constituted ineffective assistance of counsel could be argued that that was a strategy decision on the part of defense counsel. But I would take it a step further. The defense counsel was not responding to questions or issues that were being raised through testimony by the prosecution. Defense counsel, in an opening statement, in the prosecutor's opening statement, there was no mention of this arrest, specifically being a domestic violence incident with Sherry Young, his wife. It was brought out by defense counsel in their opening statement. They brought the issue to light.
Oh, I'm sorry, I misunderstood.
They brought the issue to light. If you have no further questions on this issue, I'd like to press forward. Voir dire was, looking at the voir dire, during voir dire, there was a witness that specifically stated that she knew or had some knowledge or association with Sherry Glass, who was one of the assistant prosecutors handling the case and sitting at a counsel table. Shockingly, defense counsel did not ask one question of this juror and did not object to seating this juror, and that did not exercise a peremptory in removing this juror, which frankly is shocking.
If I may, they didn't ask any questions. How did it come out that their kids played soccer together?
It came out on the prosecutor questioning of the jury. The defense counsel did not follow up with any questions or inquire further as to whether or not there was any conflict. And I think that's outrageous. Another very substantial due process issue that was discovered during this trial, during the reading of the transcript, is at some point during deliberations, Judge Thomas Picorni, who was sitting in place of Judge Burge, who had been disqualified, had a family member die, and he could not be present at the court, and a jury question, there was a jury question by the jury. And defense counsel was unavailable because he was arguing in front of this panel. I don't know where that happened, whether or not it was in this building or some other building. If it was in this building, it would have been shocking that the court would not have waited to defense counsel to finish a half-hour argument to talk about a jury question. But Judge Betlesky discussed the matter on the record with the prosecutor in the absence of the defendant or defense counsel. And together they fashioned a response to the jury question. And specifically, the jury was asking about, number one, about further exhibits, and number two, they were asking for a witness list. Now, I've seen courts give witness lists to juries to help assist them remember specifically who testified. Defense counsel was not there to give his input. He eventually showed up and objected to the fact that there had been these discussions on the record without the presence of the defendant. And the court, who had absolutely no knowledge about the facts of this case, because he did not sit and hear the testimony, gave the jury their answer to the jury question. This is a clear violation of the Due Process Clause of the Fifth Amendment to the United States Constitution. It's also a violation of the Ohio Constitution, and it's a clear violation of Ohio Criminal Rule 43A. And the case law is pretty clear that a defendant has the right, unless waived, to be present at all proceedings in court that are on the record. In this case, I believe there was actual prejudice. I think it could be shown by the record. There was approximately 25 witnesses that testified, and it would have assisted the jury in recalling the evidence if they had a witness list. And I would argue to the court that this substantial constitutional deficiency is tantamount to a lack of due process, which should cause this case to be reversed. I believe I've used my 10 minutes.
Yeah, you have.
Okay.
Yeah, you're just at it.
I would ask the court at this point, also, I think our arguments are fairly well argued in our brief, to consider the other arguments that are just as substantial in deciding this case. Thank you.
Thank you.
May it please the court, my name is Natasha Guerrero, and I represent the appellate of the state of Ohio in this matter. I'll go ahead and start off with where appellant's counsel began, being that the ineffective assistance of counsel claim. And in that, as Judge Carr pointed out in our brief here from the state, in that it appeared as though defense counsel was trying to own up to whatever wrongs that he had in that context. Therefore, being able to show the jury, hey, I can admit to what I did do, but I did not commit any of these crimes as indicted, and obviously presented a substantial case on his client's behalf in order to refute the charges that were in the indictment. And in fact, it was this altercation that actually triggered the ultimate disclosure by the victim in this case. It was the events of those nights which led to the police being called to the home that evening, and which ultimately led to the victim explaining to her mother what took place, and her eventually being taken and interviewed by the law enforcement, and ultimately into the crimes that were indicted here. And obviously, that would be a trial tactical decision, which should be granted great deference with regard to the ineffective assistance of counsel claim. Secondly, with regard to the issue with the juror, during that particular exchange on the record, the juror indicated that she recognized the assistant prosecutor, and she did bring that to the attention of the court. And there were questions asked of the juror at that point. The juror indicated that the children played soccer together, however, she didn't even know her name at all, that they did not socialize at all. Therefore, it showed that there was not any sort of relationship between the assistant prosecutor and that particular juror. So that information was already out on the record when that juror was questioned by the court, showing no particular relationship with the assistant prosecutor in that case. So therefore, the state would again argue that there was no ineffective assistance of counsel there, because that information was already out there and on the record. Next, with regard to the jury questions, the trial court judge was in fact stepping in for Judge McCorney at that point. There were two questions that were presented by the jury, one being would they be able to obtain other exhibits that were presented during trial, and secondly, whether or not they would be able to have a witness list presented to them. And The judge on the record indicated that these were normal questions with standard answers, and that he would in fact fashion the answers to those questions. The state simply stated that it had presented all the exhibits that were admitted to the jury, and those were the exhibits that the jurors actually had with them in the deliberation room. And it was the court that actually fashioned the answers of saying, number one, you have everything that you're supposed to have, and number two, there's presently no witness list. Use your collective recollection in order to remember who testified and what they testified to. And he provided that in writing and presented that to the jury. Attorney Liu then was able to review those answers, and again, it went on the record. Attorney Liu never objected to any discussions taking place without his presence. That is not contained within the record. Attorney Liu also did not object to the answer to the first question, being that the jury had all of the exhibits, which it was entitled to have. The only thing he objected to was some wording in the second question, being that the court did not presently have a jury list. He stated that he wanted it to state that there would be no jury list provided to the jury at that time. And the judge actually went in and stated, no, you would not receive a witness list, use your collective recollection. Again, Attorney Liu did not object, saying, I would like them to have a witness list. He said he did not want that to happen. That did not happen. The jury did not receive any additional information than what they were presented at trial.
Were these questions, I'm trying to remember them. The judge submitted, these were written questions?
Correct, Your Honor.
And the judge submitted written responses?
Correct, Your Honor.
And what was on the record and what wasn't?
There was the initial stating by the court what the questions were.
So that was in open court with the court reporter?
With the court reporter outside of the presence of the jury. The jury was not present. I'm sorry, Your Honor, during any of that. So that was, in fact, on the record. But there was only discussions as to what, not necessarily discussions, but here are the questions. These are common questions. This is how I'm going to answer it. And the state indicated here we gave them every exhibit that we had presented to them.
But did the court ask the state what your position is on this?
I think he asked what her thoughts were. I can't remember the exact wording of it, saying something of that. But the state only indicated, you know, we gave them all the exhibits that they were supposed to have.
So it's your position that you have to show prejudice as a result?
Correct, Your Honor.
That it's not a structural error type analysis?
Correct, Your Honor. And in fact, you know, as I stated after the fact, when Attorney Liu did become available, this all went on the record, and Attorney Liu actually never objected, never requested anything additional to be presented to the jury. And the only issue that he had was presently with regard to the witness list.
Of course, if it's a structural error, a legal issue, if we look at it legally and say it doesn't matter about prejudice, it doesn't matter that he subsequently got an opportunity to object.
And I believe actually the case Campbell is what I refer to in that, you know, it is required for the defense to be able to show prejudice as a result of all of this. And because he wasn't able to and did not articulate any sort of prejudice in his argument, that this actually was a harmless error, especially considering that defense counsel was not actually going to object to what was presented to the jury.
How would you show prejudice?
That's a good question,
I know,
Your
I'm
Honor.
putting you on the spot, but I have to do that.
No, I
show
understand.
prejudice in those situations whenever somebody doesn't have an opportunity to address an issue that's presented to a jury.
I think
in advance.
I apologize, Your Honor.
No, I'm sorry, too.
And I think here, obviously, if there would have been something after the fact, you know, the attorney came in and said, here's, you know, how this could have affected, you know, X, Y, Z, you know, especially here because we did have that, he did have the opportunity to go back and actually make any sort of corrections, and this was all took place, and Attorney Liu was able to address all of this prior to the jury coming back, you know, during its deliberations. So this actually was still in the deliberation phase and could have at that point been able to be corrected if there was any error to be corrected at that point. But again, Attorney Liu did not make any objections to any of it other than the word presently at that point, and did not object at all to the fact that this transpired on the record prior to him being able to come in and make his opinion on the answers.
It doesn't appear from either brief that there was any documents that weren't provided to the jury.
No, all the documents that were provided to the jury, that was all that it was. There may have been maybe some demonstrative exhibits, you know, but it appeared that what was supposed to be presented to the jury during their deliberations was actually presented to them. Nothing was withheld in that regard. And then I guess briefly to touch on, you know, some of the other arguments, first being the manifest weight of the evidence. The state would submit that the jury was correct in finding Mr. Young guilty of all the charges in the indictment. A lot of the argument that he did make within his brief with regard to credibility of the witness, specifically the victim in this matter, and credibility determination should be granted great deference to the jurors, the trier of fact, as they were in the position to be able to observe the witnesses as they testified and make that determination. And here, the defense was able to put on a case to try to discredit any sort of testimony that was provided by the victim in this matter. The jury had all of that with them during their deliberations, and obviously, based upon their verdict here, determined that Brittany was credible. All the other evidence that corroborated her testimony was, and therefore was correct in determining that Mr. Young was in fact guilty of all the charges in the indictment. And I believe, if there are no other questions for me at this point, the state would request that this honorable court hold the convictions of Mr. Young in this matter. Thank you.
You have about 4 minutes.
Regard to the issue, Your Honors, in regard to the issue with the jury questions, there is a transcript that reflects this, what happened. There's excerpts. It was on the record between pages 1183 and 1185. All the discussions were between Judge Betlesky and the prosecutor. This before Mr. Liu, the defense counsel, appeared. The judge asked the prosecutor directly, how do you wish to proceed in answering these questions? The prosecutor propounded a response, drafted the response, or suggested the response that would be given to the jury. And that was the response that was given to the jury. Mr. Liu had several objections to the methods of handling the questions. That's on trial transcript 1188. And subsequently, Judge Betlesky read into the record specifically the response that was prepared by the prosecutor. You have a man facing a life sentence, and you can talk about harmless error, but you want to do it right the first time, and clearly it was not done right the first time. And frankly, I don't know too many judges that would sit down with one side and discuss how we would answer these jury questions without the other party present.
Well, counsel, you may be raising a good point with that, but unless you can really demonstrate structural error, isn't that where you have to go? Because, you know, I understand your point about, you know, we talk about harmless error in this type of case. It's maybe a very upsetting concept, but with the Court of Appeals, we deal with error all the time. It's just a matter of whether it prejudices somebody's rights, because there's never going to be a trial that's perfect.
Well, how about the defendant's right to be present at all proceedings?
Well, then you're arguing structural error.
there.
Yeah, yes, and to assist as defense counsel in responding to these types of issues. Getting back to the jury, because I know I only have a couple more minutes, but getting back to the voir dire, you can minimize the impact of not asking a prospective juror any questions, saying, well, she explained that they really didn't know each other yet, but there's a lot that goes into these types of issues. I think any parent that has kids that play sports know that maybe she didn't know directly the prosecutor, but maybe she knew the prosecutor's friends. Maybe she knew her circle of friends. Maybe the two teammates that were playing on the team together, maybe they were best friends. Maybe the husbands know each other well and have sat down and had a beer together. Maybe they're classmates at school. Maybe there's team parties. How many times did this juror see Prosecutor Glass? These are all very important questions. He didn't ask one question, which is shocking, especially when you're considering somebody is facing life in prison. So you can minimize it, but these are the types of due process issues that cause innocent defendants to be convicted, and that's what I believe happened here. There was no physical evidence, no forensic evidence that established that my client committed these crimes. And I believe if the jury didn't hear all this talk that came from defense counsel about how he drinks, about how he smacked his wife in the face, and how he went to Oberlin Court and was convicted of a crime of violence, I believe they would not have convicted my client of any crimes.
And you're out of time.
Thank you.
Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as we release it on our website. Thank you very much.
Thank you. Thank you very much.